Thank you. Thank you. Please be seated. Thank you. This is the time set for oral argument in Shudak, thank you, versus Arizona Corporation Commission, our cause number 1CA CV150544. Let's begin with introductions of counsel for the appellant.
Good morning, Your Honor. Brian Shulman and Netta Gales on behalf of the appellant, Patrick Shudak.
Thank you.
Good morning, Your Honor. Ryan Millicom on behalf of the Corporation Commission.
Thank you. Well, thank you all for being with us today, and we appreciate your briefing and the time you've taken to prepare for the argument. Let me go through a few preliminaries. Each side has 20 minutes. When you go to the podium, if the appellant would like to reserve part of their time for rebuttal, if you would, let us know at the beginning of your remarks, and we'll try not to poach on your time so that you'll finish up with that time on rebuttal. We are recording the matters today, both audio and video, and so when you go to the lectern, if you would please just restate your name. That way, if a person listens in, they'll be able to identify the speaker. Let me advise the parties that we have read over the briefs carefully. We have reviewed pertinent portions of the record. We're familiar with the basic facts and your arguments. You might like to take that into account in your remarks today. We've also conferred about the case and discussed it. I think with those preliminaries out of the way, we'll go ahead and begin.
May it please the Court, Brian Shulman on behalf of appellant Patrick Shudak. I would like to reserve 7 minutes for rebuttal. We necessarily need to start with the due process argument, because if the Court finds that Mr. Shudak's due process rights have been violated, then the Court does not need to analyze the evidentiary issues. From our perspective, the Court's analysis boils down to a single choice. On the one hand, you have the line of cases holding that a party has a due process right to a decision from the hearing officer who hears the live testimony. The rationale for that well-settled holding is captured in the Arizona Supreme Court's opinion in Ohlmeyer and in this Court's opinion in Adams. On the other hand, you have Pine-Strawberry, which held that in that particular utility rate-making case, it was okay to have the chief hearing officer draft the proposed order relating to a rate increase after the presiding hearing officer had resigned. We believe Ohlmeyer and Adams clearly apply, and that Mr. Shudak's due process rights were violated when the ACC replaced the presiding hearing officer with a new hearing officer who then drafted the recommended findings of fact and conclusions of law. We start the analysis with Adams. The general rule in Adams is that where the demeanor and credibility of a witness are at issue, due process is violated if the agency does not have recommendation from the hearing officer who actually conducted the hearing. The case was decided in 1985 and cites to a long line of cases from other jurisdictions to support that general rule. The Corporation Commission has not cited to any authority challenging, let alone rejecting, this rule. It's a fundamental principle of administrative law.
Counsel, accepting everything you say is true, can't those cases be reconciled as to when credibility is and when credibility is not a determinative factor?
Yes, I believe both cases can coexist. The issue, Your Honor, is that, and I think all of these cases bear that out, particularly if you read Adams with Ohlmeyer, is that Adams and Ohlmeyer apply to lines of cases basically when live testimony is at issue.
Isn't it a little more nuanced than that if you put Pine-Strawberry on top of that as well? Doesn't it matter sort of what the throughput is?
Respectfully, no, Your Honor. In Pine-Strawberry, that was what these courts all call a cold record case, in the sense that there's nothing in the record that indicates there was any live testimony. But even if there was, there are certain types of cases, and these cases are identified in the administrative treatise that's identified by both parties and in some of the cases, where it has been determined that because of the type of case, the testimony that is presented is not necessary for the ultimate resolution. And one of those cases that is readily cited to are rate-making cases. And for Your Honor, I don't know who might be familiar among the panel with the utility cases at the ACC, but the common practice at the ACC is to submit testimony in written form. Of course, Pine Strawberry doesn't give us any indication of whether there was any testimony at all, let alone live testimony. But
it does tell us that credibility wasn't at issue. Fair? In Pine Strawberry?
No, I don't believe. I don't believe that Pine Strawberry goes into the analysis that's necessary to actually.
And I understand you may disagree with it, but it doesn't. There's no hint in there that credibility was an issue. Fair?
Yeah, I think that is fair.
And aren't there some analogous cases for bench trials in the trial court context? For example, in family court, when a judge who hears the testimony and then becomes disabled, or retires or goes somewhere and can't issue the decision, that a new judge who takes over that case may or may not need to sort of start all over again, depending on whether credibility is at issue.
I would agree with you, but with this condition, Ohlmeyer goes into great lengths to discuss what is credibility, what does credibility mean in this context. And in fact, in Ohlmeyer, where the Supreme Court reversed the Court of Appeals, which tried to make a distinction with Adams, in Ohlmeyer, the Supreme Court talked about what does credibility mean in this context that's relevant to our case. And credibility is not just about truthfulness. Credibility is a much broader concept in this context. So with that, I just wanted to make that point that when I'm talking about credibility, I'm adopting the definition, the broad definition of credibility that is referenced in Ohlmeyer by the Arizona Supreme Court.
Let me ask you about that. Having read those cases and read pertinent portions of the record, I think the cases can be reconciled by the importance of credibility in as you define that, because I think that's supported by the case law. The problem I'm having here is when I look at the briefing on appeal, I don't find any real specific, I don't find any statement, this was not credible, or this person said this, and that depends on credibility. For example, in the opening brief at PDF 26, it would be our PDF number 26, there's a statement, ALJ Stern also repeatedly questioned the credibility of witness testimony. I've looked at the citations. I did not. Frankly, I think that characterization is not borne out by the statements, the record cites. I'm not finding anything in this record that would suggest to me that there was really a credibility issue, perhaps that someone's demeanor did make a difference, and that ALJ Martin needed to actually see the person face to face to make an assessment as to what that person was saying and whether that person's testimony was credible. I just don't see it anywhere in the record.
Taking Ohlmeyer's definition of credibility, which goes to anything, and I'm quoting, anything which throws light on the accuracy, truthfulness, and sincerity of the witnesses. If we take that definition, I'll answer it a couple different ways. First of all, there was a very specific and explicit issue with respect to the credibility of Mr. Schwank, who was one of the witnesses. There was...
what was the issue with respect to him?
Yes, so the issue was there was a cross-examination by me of Mr. Schwank related to a hospitalization that he had attended to that was in connection with how he met Mr. Shudak. And my question, which was objected to by the Securities Division, went into the reasons why he was hospitalized and whether or not that hospitalization and his medical treatment had any impact on his memory and credibility. And in fact, credibility is in fact discussed in the dialogue with ALJ Stern. Mr. Stern, Judge Stern, overruled the objection and allowed me to ask the questions with respect to Mr. Schwank. So that there is an explicit aspect of that. But let me pull back even further. Again, under Ohlmeyer and what they really are talking about with credibility, this case was fraught with conflicting testimony. And what I mean by
Can I
that...
jump in? Because I see a possibly different analytic framework, because we know from the case law that it's the commission's final decision we're reviewing, not the ALJ's. You would agree with that?
Yes.
And we also know from agency cases like Ritland that the final decision maker can substitute its views of the credibility of witnesses for those of the underlying hearing officer, ALJ, et cetera. So doesn't that make a difference here? We're looking at a different layer. We're looking at the commission's final decision.
Well, that's the decision that is being appealed, but all the cases talk about the requirement that the fact finder be the person or party that hears the testimony.
Yes, but we know from Ritland that the final decision maker can substitute its views of credibility. So if there were issues of credibility, I guess I'm not understanding why we're focusing on a layer that's not really what we're reviewing.
Well, let me, I think I understand the question. The issue boils down to, I think the cases are clear, Ohlmeyer and Adams and the progeny of cases that preceded it, that somewhere in the process, in a case where witness testimony is presented, live witness testimony, that the officer that is providing the findings of fact, recommendations of findings of fact and conclusions of law needs to be the officer that hears the testimony. I understand the distinction between an agency where the commission is the entity that issues the ruling, as opposed to at the corporation commission where the hearing officer just makes a recommendation and the commission approves. But I would argue,
or doesn't approve,
or doesn't approve. I would say, not that it's dispositive of anything, but in this case, the commission adopted without making a single change to the recommendation. I would argue that in this analysis, for what we are looking at today at least, the distinction is without a difference, because you still have, we are sitting here today, 3 years later, and I'm before this honorable panel, and Mr. Shudak has not had any ruling or findings from any judicial officer who has actually heard the live testimony. And as we've argued in the brief, I think that is a blatant violation of due process, and I think that speaks so much to the fact that this was an unfair process.
But to follow up on Judge Downey's question, given the way the ACC hearing process is structured, he never would have that. The commission is the body that speaks, the commission as a whole, and they can accept a recommended opinion, they can accept it in part, or they could reject it. And if I hear you right, what you're saying is if the commission, instead of affirming, found, let's say an ALJ, hypothetical, okay? ALJ expressly says, all these witnesses were completely credible, I accept 100% of their testimony. The logical conclusion of your argument is the Corporation Commission could not then say, well, actually, we have credibility concerns about some of these decisions, even though they're the final decision maker. They couldn't do that.
I think the line of cases actually are pretty clear that that's correct, that when it comes to credibility, that the credibility issues should be decided by the judicial officer that hears the testimony.
And you get there from the Adams and the Ohlmeyer cases, which are decided in a very different procedural context. Workers' compensation, I see, is structured very differently than the Corporation Commission.
I agree.
And Ritland, which specifically says the final decision maker can overrule the person who heard the live testimony's credibility determinations.
If we were to take that position with respect to the way that the Corporation Commission is set up and how they do their proceedings, then you would almost you would create a dome over any decision that comes from a hearing officer in that case, because they would always be protected by that layer of the commissioners, frankly, doing the perfunctory mechanism of adopting a recommended order.
Well, and I understand your perspective, but are you effectively taking Ritland head on? Are you saying it was wrongly decided?
No, I don't think I need to say that. I believe that if you read Adams and Ohlmeyer, there is strong language, particularly in Ohlmeyer, which is taking to task the lower court's ruling where they try to distinguish Adams. And Ohlmeyer, I believe the Supreme Court is making it clear with very, very broad mandates about what is required by a hearing officer when there is live testimony, that their application is not at all limited to the specific process that exists with the Industrial Commission. There's no language in Adams or in Ohlmeyer that says our analysis only applies to this particular process.
And that's fair, but there's also no statement saying it applies to the Corporation Commission either. I mean,
that's true, but I would argue that the tenets that are laid out in both of those cases, there's no reason to not apply those to the process that's in place at the Corporation Commission. There's no conflict with the analysis in Adams and in Ohlmeyer such that you could apply that analysis to the commission process. So I know that I've gone beyond the time that I wanted to reserve, but I did want to respond fully to Judge Norris's question about this issue of credibility and whether there was credibility in the record. Again, under the Ohlmeyer definition, the credibility extends to not just truthfulness, but also to the extent that there's any conflicting testimony. And in this case, Your Honor, there's a lot of conflicting testimony in the sense that there's conflicting testimony throughout the record about what each investor received, what each investor read, what each investor heard, what each investor knew, and what each investor believed.
There's 18 investors and only 3 testified, so we're only talking about the 3 who testified because the others were not there. There's nothing to evaluate for them. I mean, they didn't testify, so their credibility is irrelevant. It may well get to the documentary record as whether they all received the same written materials.
Right, but I agree. But the import of that in this context is that this division argued and the hearing officer accepted this argument that the three investors who did testify, those stories were all different, materially different. They all came about their investments different ways. There was no pattern that could be deciphered from that, such that you could take the testimony from the 3 investors who did testify and extrapolate that to the majority of investors who did not testify. The significance of that is that you had conflicting testimony from the 3 investors who did testify, and ALJ Martin, who did not hear any of that live testimony, not only resolved the conflicting testimony among the 3 witnesses, but then applied it to the other 15 investors who did not testify. That goes to credibility, big C, under the Ohlmeyer definition. I'll reserve the remainder of my time. Thank you.
May it please the Court, Ryan Millicombe for the Corporation Commission. The primary issues on appeal in this case are whether the Corporation Commission's decision is supported by the substantial evidence and also whether the plaintiff, Patrick Shudak, and his entity, Parker Schuyler, received substantial due process, where in this case he had a notice of the allegations against him. He received copies of the division's almost 50 exhibits consisting of the documentary evidence, a list of the potential witnesses that would be called at hearing, a full 3-day evidentiary hearing where he was represented by counsel and where he was able to cross-examine the witnesses, including the three investor witnesses, as well as division employee D. Martin, who testified as to the experiences of 4 other investors. He was also able to review the documentary evidence and object to it before it was put into evidence. After the hearing, he was able to file a post-hearing brief with his arguments. He received a copy of a recommended order to which he was able to file exceptions, and he was also able to voice his exceptions and his objections to the recommended order to the ultimate decision makers in this matter, the commissioners. The due process at issue is procedural. That gives a person an opportunity to be heard in a meaningful time and manner. As I stated earlier, we had a full evidentiary hearing that lasted 3 days. Mr. Shudak claims that having Administrative Law Judge Martin draft the opinion, the recommended opinion violated his due process. But it is the commissioners, not the Administrative Law Judge, that issues the decision. As stated in Ohlmeyer, where a commission makes a vote, having reviewed the final transcript, no right has been violated. Additionally, as in Adams, a decision from this court, it says this court recognizes that where final administrative decisions are made by agency boards or commissioners, the commissioners themselves need not personally observe the witnesses. Adams also cites to a general principle. To the extent demeanor is important in this case, this principle applies. It states, the principle which should govern substitution of hearing officers is the simple one that demeanor of witnesses should not be lost from the case. Whoever observes the demeanor must report it to the decision makers. If demeanor is unimportant because all of the crucial evidence is documentary, no such report is needed. Here, the vast majority of the evidence is documents. That's where many of the representations were made. That's the evidence of the security, the notes, the membership interests. However, this evidence was supplemented by witnesses, 3 investors, and a division employee.
Counsel, wouldn't you agree that the better practice would be to have the same ALJ preside over the evidentiary hearing and then prepare the proposed order?
I believe it would be a problem, as Adam says, if demeanor were lost. Here we were fortunate enough to have the ALJ, Mark Stern, appear at open meeting and report about this to the decision makers, the commissioners.
Right, and that postdated the hearing by 15 months, something like that?
Over a year,
longer?
that's correct, yes.
Right. Wouldn't it be the better practice to have the same ALJ do the whole thing?
It has been typically the practice. I believe it would be better. For example, at the very least, we'd avoid issues on appeal to such things.
And let me ask, does the recommended decision make plain that credibility in the large C way, as your opposing counsel has suggested, did not play a part in the decision, or was it the open meeting dialogue?
I believe it was the open meeting. I don't recall the word credibility being used in the actual recommended order. What the recommended order does do is it goes through the witness testimony and the documents. It then goes to Mr. Shudak's arguments. Those are from his briefs and cross-examination. There were no conflicting witnesses. And thus the credibility comes in more through the record and the testimony.
Couldn't, though, credibility be an issue even if witnesses' testimony didn't conflict?
Didn't conflict with other witnesses?
Anything.
Credibility could be an issue, yes, and I believe that's what this quote from Adams, the general principle, is capturing, that demeanor should not be lost. I suppose, since we're talking somewhat hypothetically, I suppose someone could come across as deceptive. Is that what you're getting at?
You could have a one-witness hearing where credibility was an issue. Fair?
That's fair enough.
And what would have, if the first ALJ said something that trial judges typically do and are actually encouraged to do in making findings, something along the lines of, having weighed and assessed the evidence received, including credibility, I make the following findings. Would that result in a due process violation in this case?
If there was a clear record that...
If the recommended decision said just what I sort of dictated.
I'm not 100% sure I understand. The record would have shown that the credibility was at an issue.
Recommended decision has a line in it after recounting the evidence in some various ways. Having weighed and assessed the evidence received, including witness credibility, I propose the following findings. Would that be a different case? Would that put us into a different line of cases?
I don't believe it would. I believe that it's implied under the Seiler and the Sigmund cases that is the duty of the hearing officer to weigh the credibility. And I believe that's what you have here, is you have not only cross-examination from Mr. Schulman, you have questions from Judge Stern. That's all in the record.
But remember, I'm talking about with the same two-step. You have two ALJs, one that presides over the hearing, the other one that writes the decision. And the one that writes the decision
I
is
see what you're saying. The one that just writes the decision says there are no
having weighed
issues
and
with
assessed
credibility.
Well, it doesn't even say there's issues, but having weighed and assessed credibility is vague.
I understand. I believe if there were nothing else, that it would be difficult for that judge to make that representation. Now, and that would be based on your hypothetical earlier, that maybe there was something in that person's demeanor, maybe they winked, maybe they came across as deceptive.
We don't know.
We don't know.
All we know is the second ALJ
yes,
said
in that
having weighed and
hypothetical
assessed.
situation, I could see that being a problem. That's not what we're presented with here.
Right.
What we have in the open meeting is the word demeanor comes up 3 times from no less than Judge Stern, who reports that the demeanor was excellent, these witnesses were excellent, we couldn't ask for better witnesses.
And what's your response to the thought that especially the investor witnesses testified differently?
They testified as to how they met him differently, certainly. One met him after a soccer game. One met him through an investment advisor in Omaha. That is different. I don't see that as a conflict. What they all testified to was that Mr. Shudak met with them, described an investment, and signed documents giving them that investment. I'd like to point out that the Pine Strawberry case does support the Commission's decision. The Commission has a rule as to directing the appointment of judges. Pine Strawberry addresses that specifically.
Same rule applicable in this case?
Yes.
And was it complied with?
In this case, yes.
How do we know that?
What we have here is that the commissioners appointed a hearing division, a hearing officer. At the open meeting, they discussed the hearing officer's decision to appoint a different administrative law judge. After a lengthy discussion and stating that they were satisfied with that, they ratified the decision and then unanimously approved the opinion.
And what's the text of the rule?
The text of the rule is, this is Rule R14.3.110b. It states that in a proceeding heard by a hearing officer, the hearing officer shall prepare his recommendation, which may be in the form of an opinion and order, unless otherwise directed by the commissioners.
And so the otherwise directed by the commissioners, your construction of that rule means if people get busy, they can have a different ALJ draft the recommended decision.
They can defer to their...
Or busier. I don't mean to imply they're not busy already.
Right. Yes, that is our construction, that if the person in charge of their hearing division that they've appointed has decided for docket management purposes that to move this along to encourage the speedy decisions, then yes, that is appropriate.
And so the unless otherwise directed refers to assignment of the ALJ as opposed to what should be prepared by the original ALJ.
Yes. If you read the sentence, I think it applies to both, but as I read Pine Strawberry, that was the exact issue where a judge retired and then the commission directed another one.
And what's your response to the thought that Pine Strawberry was rate-making case? We don't even know if there are witnesses there.
It says that the person making the decision had access to the testimony, the recorded testimony. Uses the word testimony. It was contested. That's why it was on appeal.
Well, rate-making case can be contested
yes.
when, you know, the body of evidence is sort of what it is. It doesn't mean...
I would say that gets more to the evidence proving the rate-making case and the decision. Obviously, we had to bring documents, one for each investor, to prove our decision. It's not just that we're saying, look at this procedural appointment. It's does the substantial evidence still satisfy our burden. We don't think that waives that. That the judge making the decision would still have to rely on the substantial evidence in the testimony. They would not be able to get away from that. And I think that's what you have here. If you look at Judge Martin's opinion, it's a very long, detailed opinion. Goes over the evidence, goes over the testimony, includes Mr. Shudak's arguments, and then reaches its conclusions.
Counsel, you did not cite Ritlin for the proposition that I was exploring with Mr. Schulman, but it's a much more recent decision from 2006 in some of these other cases, and it stands for the proposition that the final agency decision maker can substitute its views of credibility for that of the original fact finder. So doesn't that in some ways obviate the need for us to focus on this micro level of fact finding and look instead at what the commission could, as the final decision maker, do?
Yes, I agree that it does. And as I said earlier, I think both Ohlmeyer and Adams do say that the commission is the final decision maker. Pine Strawberry says that as well, that they are not bound to the recommended opinion.
Ritlin goes further and says even credibility can be substituted, judgments of credibility by the fact finder. That's a 2006 decision, and it seems to me to be pretty applicable here with the final fact finder. Kind of a no harm, no foul rule if the final fact finder adopts the recommendation of the second ALJ.
Yes. Can you tell me what your question is one more time? I'm sorry.
Well, I'm just kind of wondering why you didn't take on Ritland, because it seems to help you. And I'm wondering if there's something in Ritland that you think is distinguishable that we shouldn't look to.
No, Your Honor. I mean, honestly, it was that Pine Strawberry said that. It said that they didn't have to accept the recommended order. It was up to their discretion. They were the opinion maker. And for that reason, I felt I had enough case law. For the most part, we've talked about procedural due process, but just very quickly, to the extent that there is any substantive due process, I believe that's satisfied as well. This Court's opinion in Martin versus Reinstein says that substantive due process protects against wrongful, arbitrary actions that shock the conscience. Here,
Counsel, do you read appellant as raising a substantive due process argument?
I read appellant as saying it doesn't matter to distinguish between the two, and I believe that it's important to say, well, either one, their argument fails, whether it's procedural or substantive. And I can make this point quickly. I don't think that there's anything shocking in here. I think that a quick reading of the decision, its amount of detail, and its respect to both sides' argument take away any shock value. Along with that, you have ALJ Stern saying that he would have signed the exact same opinion, that he agrees with it completely. The decision itself is supported by the substantial evidence. It's undisputed that plaintiff and his entity sold unregistered securities and that they were not registered to sell the securities. Plaintiff argues that the securities and transactions were exempt from registration. It is his burden to prove this exemption, and he did not do that. In State v. Bauman and under ARS 44-2033, it is required, it says, this is in State v. Bauman, because of the vital public policy underlying the registration requirement, there must be strict compliance with all the requirements of the exemption statute. In SEC versus Murphy, this exemption requirement, proving the exemption, is not only necessary for the investors, but to each offeree, and a failure to state how many offerees existed in this offer is fatal to claiming the exemption. Here, Mr. Shudak opted to present no witnesses and not to testify himself. Thus, he presented no evidence as to the number of offerees. This is fatal to his registration exemption claim. He also claims that he is entitled to reasonably rely on investment purchase agreements signed by the investors, stating that the investor was able to discuss the investment with Shudak, and that the investors also completed an investor suitability questionnaire regarding their status as a accredited investor. This fails almost immediately because 3 investors didn't sign those documents. The investors, Mr. Lamer, Mr. Ope, and Van Hook, signed documents that contain no such representations. Additionally, there's testimony that one investor told Mr. Shudak that if Mr. Shudak could guarantee that there was going to be a 14% return, he was not going to look at 50 pages of documents. It's unreasonable to rely on representations made by an investor who says, I'm not going to look at the representations that I'm signing. There was only, as to the investor questionnaires, there was only evidence that 5 investors filled out the questionnaires that detailed that they were accredited. Those were provided by the division. There is no evidence that Mr. Shudak reviewed these questionnaires, much less reasonably relied on them. Finally, as to being able to discuss the investments, the standards in Ralston-Purina, that is, whether the investor has the information available in a registration statement available to it. Here, there is no evidence that such information was available, and though it was not necessary, the division did provide evidence from some investors saying that when they requested financial statements and documents, they were not provided. Because Shudak failed to establish evidence of an exemption for their offering, the Commission properly found that 90 total offers and sales of 2 different securities occurred, and that these were in violation of the registration requirements. The Commission also found that there was fraud in connection with the 90 offers and sales, and this is also supported by the substantial evidence. This holding is in paragraph 171 and 182 of the decision. The holding says that there was a violation of 1991. The order simply says that there was fraud in connection with each offer. It does not say that there were 4 frauds in connection with each offer. And it's clear that a single fraud to each offer came about because what you have when they tallied up the potential violation, the potential penalties for violations, they said you have the 90 registration violations plus 90 fraud violations. Times 5,000, that could have been 900,000.
Counsel, what's your response to the argument that substantial evidence of fraud with respect to each investor was both required and not provided?
First off, it is required that there must be fraud. Second, it was provided. First, there are 4 distinct frauds. One of them is oversubscription. What you have is a document given to each investor with a percent symbol and the word percent next to it. The ALJ and the Commission held that those would have taken on their plain English meaning to the persons receiving these documents, that is 1 out of 100. So you have that for each and every investor, 1 out of 100. And that oversubscription occurred fairly soon. Afterwards, of course, after 100% had been subscribed, nearly $750,000 were sold. The other ones, I don't think it's anywhere, it's certainly not anywhere in the notice, and it's not in the decision that they applied to all investors, but there's certainly evidence that they applied to almost all of them. For example, the lien encumbering all of Parker Schuyler's assets was was made and recorded in a UCC statement after only the first 3 investors had invested. Thus, you have documentary evidence. You have the assignment of membership interests. Each contains a representation that these interests being purchased are unencumbered. So you have a direct documentary evidence for all but 3 of the investors. That constitutes an additional fraud. You have another fraud is Mr. Shudak's failure to disclose lawsuits and default judgments against him. The first of these was in June 2008, when only a handful of investors had invested. I'm sorry, I don't have the exact number on me, but the majority invested after this date. You also have the documentary evidence showing that people expected their investments to go to financing of real estate and the purchase of real estate. The Commission properly held based on evidence that the investors would expect Mr. Shudak to have a basic competence and understanding of financial matters, and that knowing of these lawsuits and judgments by creditors would be material. Finally, you have one called the mishandling and misuse of funds. This was largely based on representations in an operating agreement. The evidence at hearing was that 2 investors received the operating agreement and made their investing expectations based on that. As a final matter, just would like to talk about the restitution amount ordered and the way of calculating it. I believe this is very straightforward. The Rule 20, our statute 2032 was recently interpreted by this court in its Hirsch opinion, saying loss causation does not apply to enforcement actions brought by the Commission. That decision talks about the Commission's rule of using fair market value. Here, as we read the decision, we see an extensive effort to document each and every payment with 2 data points. We use both their investor documents, and then we use bank statements, bankruptcy documents, checks to calculate a full restitution amount that's in compliance with the rule. If there are any further questions, I'll take those. Thank you.
Thank you. I'd like to make 3 points and answer any last questions. First, let me address the substantial evidence issue. You can get that out of the way. We make the arguments, we'll rest on our briefs, but I think the point that needs to be made is this is not a case like Carlson. And I know, Judge Downer, you wrote the opinion in Carlson.
Reversed in Carlson. I was the trial judge in Carlson. That's a sore point with me.
Sorry.
That's all right.
In that case,
Doesn't hold grudges.
But I remember that one.
But this was the infamous Radical Bunny case. There were 900 investors. Nobody is suggesting here that you need to parade 900 investors. But in that case, the division proved that all the investors received the same loan documents, 2 different loan documents, and that the misrepresentations and omissions were in those loan documents. Here, no such pattern was ever established. There are evidentiary holes throughout where there is no pattern such that you can make those broad claims. And our argument throughout our briefs is that there are voids in the evidentiary record with respect to the investors who didn't testify. So this is a much different case than a case like that or a class action case. Second point, the division argued in its briefs and brings up here this dialogue that happened at the open meeting where hearing officer Stern told, I can't even say testified, told the commissioners that he conferred with ALJ Martin and that they saw eye to eye on things. I would argue that is not the formal process at the Corporation Commission or any agency, and this after the fact Band-Aid that could be put in place for this serious due process violation cannot be condoned as a means of remedying an otherwise violation of due process. Frankly, I would argue it's insignificant. Lastly, I want to take on Ritlin head on. There's a lot that's been discussed about it, and I candidly refreshed my memory on Ritlin.
I thought you might.
So in Ritlin, as you will all know, I mean, they do cite to Ohlmeyer, and they reckon.
First on that one as well, I believe.
No.
I think you did.
And they discussed the need to reconcile Ohlmeyer with the ultimate decision, the holding that they make, and I think they do. Their holding is that because the board and not the ALJ issues the final administrative decision, the board is not bound by the ALJ's findings of fact, including those related to credibility. Then the court goes on to say, at the same time, we recognize the importance of the ALJ's observation of the demeanor and attitude of the witnesses when rendering findings of fact as to those witnesses' credibility. Such recognition should not escape the board. While the board is not bound by an ALJ's credibility findings, those findings are entitled to greater weight than other findings of fact more objectively discernible from the record. Then it concludes by saying, thus, while the board should give deference to the ALJ's credibility findings, it may overrule these findings only if it finds evidence in the record for doing so. I would argue that this case is all about, in this context, the context of Ritlin, what deference, if any, the board must give the ALJ with respect to credibility. That's point one. Point two, I would argue, that analysis is of no relevance to the due process analysis in this case. As the court in Ritlin found, Ritlin can stand right next to Ohlmeyer, and they do not, there's no reconciliation necessary. I know I'm out of time. My last point, if the commissioners had attempted to make their own analysis and findings with respect to credibility, then I believe that Ritlin becomes part of the analysis. And then we're sitting here having a discussion about how to reconcile Ritlin and Ohlmeyer. But the fact that the commissioners didn't undertake that task, I would argue that Ritlin is not relevant to the analysis. Thank you.
Thank you for your arguments and your briefing. We appreciate the time you spent teeing this up for us. We really do. We'll take this matter under advisement, and we will issue a decision in due course.